County, and we were thrilled that they were wanted to do that. We've got right now over 90 people on here, so we have a lot of attorneys, obviously, who are interested in this and are interested in what is going to happen here in about 10 days when we're ready to open up. I want to also thank Chris Reese from the DA's office and Bob Pollock from Court Administration, who are also on this call. I think they're going to have some information to share also. So I'm going to start it off by turning it over to Judge Duple, who has been my main contact to organize this, and let him take it from there.
All right. Thanks, Dan. First off, I need to give everyone a disclaimer that I always do when I do a bench or a meeting with the Bar Association. We have 18 district courts in Bucks County, and we have 18 different ways we do everything. So we're going to give you some generalities today, but if you have specific questions or concerns, you should talk to the district judge who your case is going to be presented in front of, just to make sure what you were told here today is something that they are considering, or at least find out how they are going to modify that. As Dan stated, I was told that we're going to have 17 of our 18 judges here in attendance. We also have Chris Reese from the DA's office and Bob Pollock from Court Administration. So procedurally today, we're going to discuss generally what to expect when you come to our court. Then we're going to go into the individual areas: criminal, non-traffic and traffic, civil, and landlord-tenant cases. And again, if you have any questions during the meeting, you can put those, type those messages in, and Dan Keene's going to be monitoring that for us. When you come to the courthouse, obviously different courts have different layouts, but for the most part, when you come, well, even before that, when a notice goes out for a hearing, the judges have, most of the judges have put some distancing guidelines in the notices. And we also, today, the court, the county put some notices on our front door. Basically, when you get to the court, we're asking that you do not enter the building. You're going to be given a number to call to check in and then receive further instructions. Face masks are going to be required to be used while you're in the courtroom or while you're in the court facility. You can wear gloves if you wish. We're asking everybody to bring their own pen. That sounds silly, but again, we're trying to limit the amount of items that need to be shuffled amongst different people. If you don't have if somebody doesn't have a cell phone, then we'll make other arrangements for them to before they come into the courtroom. The county has allotted us some additional cash so that we can hire our constables to be present. Now, at least initially, we're going to have constables there at most of the courts, and again, it's up to the individual district judge, but there should be a constable who's also going to help monitor things outside to make sure everybody's following the socially distancing guidelines. I don't know if any of the judges or Mr. Pollock, if you have anything to add on that. All right, on criminal hearings, for the last several weeks, we have had available to defendants the ability to waive their preliminary hearings if they wish to do that, and we use the Blue Jeans app as opposed to what we're on now, but it's virtually the same. That's going to continue for out of custody cases. If you have a straight waiver where there are no amendments or anything, you can contact the court, make sure the judge is going to allow that case to be waived virtually. You would schedule a time to do the waiver. The court will contact the affiant to check if there are any amendments to the complaint. If it's a DUI, we'll get the BAC from the officer, so we have all the paperwork for the crane evaluations and everything to go. Once we gather all those documents, we will email them to you, and then we will conduct the hearing the same as we do for our preliminary arraignments through the Blue Jeans. You would have your client either at your office or they would be somewhere as well virtually. They're going to sign those documents, and then we're going to give them their arraignment date, give them all the signed documents, and that's how we will proceed. Chris Reitz, as I understand, has set up or they're setting something up with the district attorney's office where if you have a case that will probably be a waiver with some negotiations, you'll be able to contact the district attorney's office. And I'm going to ask Chris if you can explain the procedure that you're setting up.
Yeah, thank you, Judge. And this is going to be a little bit more reserved than my normal presentation because I listened closely when I learned that it was being recorded. So perhaps I hope everyone's expectations are lowered accordingly. The plan is if you have a client who is in custody or out of custody, honestly, you can reach out to my office, and what we will do is assign that case to whoever has the preliminary hearing duties on the date your client's case is due to be heard by a district court. We don't know what the level of interest will be in this, so we can't give you a guess as to how fast we will get back to you. Obviously, what we would prefer is to hear what you would like as opposed to make us an offer. But you know, I think the easy cases are going to be the same as they have always been. You have a retail and an RSP. Think about getting an offer to the retail and a withdrawal of the RSP for a waiver and a plea. There are going to be cases that are more, complicated than that. There are going to be cases where we're required to have a conversation with victims before we can make agreements, but we'll try to do that. We will continue to staff 3 attorneys every day for preliminary hearings. And I'm sure you're all thrilled to know or recall that we will continue to have interns assisting this summer. Hopefully that makes things go easier, though not for you or your clients, but perhaps just for the typical business of the courts, and we can churn through some of this backlog a little bit more quickly, as you would expect. Have we said something about in these troublesome times or whatever? Isn't that a requirement in every gathering? We talk about how the times are troubling, etc. In these troublesome times, I would ask everybody to be patient. Feel free to remind us. Feel free to not remind us more than once every 24 to 48 hours. We will do everything we can to respond to you. But again, I don't know what the timetable is going to be. Is that what you had in mind there, Judge Duple?
Sure, that's fine. If you have a negotiated waiver from the district attorney's office, we're going to ask the district attorney to email the judge and also CC defense counsel with whatever that agreement is. And then once we get it, we'll pretty much do the same thing as we're doing on our straight waivers. In other words, we'll set up a time for you to have your client and you meet with us virtually and go through the colloquy for the preliminary hearing. We'll amend the charges as have been agreed upon, and then we'll send them up to the Court of Common Pleas in the normal course. In custody cases are going to be a little bit more difficult at this point, and we'll talk about that in a moment. But any case you have, if you can do it, if it's going to be a waiver, whether it's a straight waiver or negotiated waiver, I think it would be in everybody's best interest if we do that virtually. That way, the only people who are coming to the hearings are those who need a hearing, or they, for whatever reason, they can't work it out beforehand, that they can work it out there, because we still need to try to limit the amount of people who come into the court. And as I said, once you come to the court, you're not going to be entering the building until you're called in. We're going to try to have negotiations areas set up outside, weather permitting and courthouse permitting, to have additional discussions. And then we're basically going to ask you to wait in your car or somehow otherwise socially distance in the parking lot until you're ready, until we're ready for you to come in. And we're only going to have one case come in at a time into the courtroom for the hearing. So again, if you can do anything to prevent having to come here and handle these things virtually, that that would be greatly appreciated. For in-custody cases, Judge Baranowski, you've been involved in a committee that talks about that or is dealing with that right now?
The prison has some equipment on order. As everybody knows, the prison has been in lockdown due to COVID-19, and that's going to exist for some time. They follow the directions from the Dr. Damsker from the Department of Health. So right now, everyone's confined to their cell. If they're connecting by video, they're bringing either a cell phone or a tablet or something so they can communicate from their cell location. But they are making that accessible. They do have equipment that is ordered. They are expanding their video capabilities to make a video court per se at the jail. Once that equipment comes in, they'll be getting that set up. We have some capabilities now. From those from the Supreme Court order, ACT, Advanced Communication Technology, is encouraged. And it's my understanding from court administration that the President Judge of Bucks County, Judge Bateman, is also going to be coming out with an order extending that even after June 1st when we open, that video capabilities can continue, ACT. As you know, under Rule 215 for civil procedure, that's been authorized where we could use video for civil proceedings. It's my understanding that the Supreme Court has actually sent to the Criminal Rules Committee to redo Rule 119 to extend also the video, the ACT capabilities for preliminary hearings and criminal procedures in the future. But going forth, it's going to be my understanding as of now that it's going to be up to the judge if he wants to conduct any and all his proceedings by ACT. With that in mind, of course, the court, as Judge Duple mentioned, the court system, Common Pleas, and MDJs use Blue Jeans, which is a free software app based. Anybody can download that on a smartphone, tablet, or their computer. It operates just like Zoom that we're using now. Blue Jeans is one of the big three. Zoom has some security issues, but it's also good. The court will be the administrator for the Blue Jeans rooms. When we are logged in as the administrator, we will have the capabilities to send parties to private breakout rooms so an attorney can confer or speak with their client privately. And then when you're done that conversation, you can end that private breakout room and come back into the room where the judge and all is in for the proceeding. So that is pretty good. Of course, if we're doing a hearing, I mean, especially well, if it's an incarcerated defendant, obviously the defendant's not going to be here. He's going to be communicating from jail. But we can also do these Blue Jeans preliminary hearings for non-incarcerated defendants. However, if we do that logistically, it would be a lot easier if the attorney did not show up in court either. Whether he is with the defendant at the office or they're both at different locations, in order to use those private breakout rooms, both party, the defense attorney and the defendant, would have to be in that room virtually so we can use that. Otherwise, if the attorney's in the courtroom and wants to communicate privately with the client, he'd have to use the court system and everyone else would have to leave the courtroom and come back in. Logistically or procedurally, that would probably be impractical or certainly cause quite a delay. So if the defendant doesn't want to show up, counsel would have to appear virtually also. That would just be a lot easier. To schedule any preliminary hearing, the court, all we have to do right now is we have to email Dave Kratz in order to schedule that and make it available. Temporarily, for the time being, Common Pleas courts will be using the video capabilities in the morning, and the MDJ courts will be using video in the afternoon until they get more equipment and get the video court up and running at the prison. As you know, all proceedings by the court by rule are open to the public, so therefore those Blue Jeans videos are still open to the public. Anybody, if they want, can be given the room number and can dial in and observe and listen to that room. The administrator, the judge, will have the capability to obviously mute everybody so you don't have background noise or anything else going on in that room. I've spoken to Brenda from the Bucks County Court Reporters, and Court Reporters, they've actually done some virtual hearings in other counties. They did a homicide one in Monco. It took a couple tries, but once they got some of the glitches worked out in the technology, they were able to do that. So even the court reporter, you can arrange for them to attend virtually if they so desire. Keep in mind that not everybody, not all the 18 MDJs have all that much experience with this. So while these video or ACT platforms will be a learning curve for the attorneys, they will also be a learning curve for all of us judges in that too. So keep that in mind. I think that covered everything.
And Judge, let me just interrupt with a few quick things. First of all, I see Matt Weintraub joined us, so I want to say thanks to Matt for being here also. Chris Reese was trying to cover it, but it was probably good that you came in also. it hasn't gone well for him so far. If you look at his picture, you'll understand why.
I'd like to enter my objection to the assembly judges, please, if you could make a quick ruling.
So we had a couple of quick things on the side I wanted to ask about these issues you were just talking about. One, somebody had asked if there's going to be, if any of this is going to be written anywhere that people can access again later and provide to their clients. Do we know that?
I don't know that there would be anything written or not. And again, it's really going to be judge specific because as Judge Baranowski pointed out, some of us are more able to do these virtual things than others. So if a judge says that they can't do this or they can't do that, I think it's best if you have them call the individual court to find out what their specific procedure are going to be.
Okay, and
we can try and work out some general instructions, and we'll distribute it among ourselves. And if everyone's in agreement with that, then we'll forward that to you, Dan, for something to go.
We'll definitely distribute that. The other question we had was when we go to individual courts, will we expect that there'll be multiple cases scheduled at the same time or spread out over time?
We have been instructed to not have like a call of the list like some courts might do currently. I know at my court I have them scheduled once every 20 minutes. So there's only going to be one case, and 20 minutes later there's another case, 20 minutes later there's another case. Unfortunately, to do that, I can only schedule 10 preliminary hearings a day. My court, I can probably get rid of my backlog doing that in a month and a half or 2 months. Some of the other courts, it would take them 2 years to get through, only doing 10 a day. So again, it's going to be court specific, but we're trying to limit the amount of people who are scheduled to be at the court at any one time to make sure that we don't have more than 10 people in the courthouse other than staff at a time, and also congregating outside where for the courts, I have the ability to have people congregating outside.
And then we have a few questions and answers on the side that deal with whether the courts will still handle waivers by email as they've been doing, or by email or mail as they've been doing the last couple of weeks.
Again, I think that's going to be court specific. But if your district judge has been doing it before COVID, I suspect that they will do it now.
Okay. And then we had a question about, I think, summary offenses, which I think you're going to get to that next. Is that right?
Yes.
Okay, so I'll hold that one for now.
Do any of the other judges have anything to add or modify?
Yeah. Dan Keene, do you think it would be helpful to everybody that's there, to us, everybody speak briefly as to what they're going to do initially? And, this is going to be a work in progress as it goes along because, maybe some of the constrictures are going to change or whatever. And then you'd have some idea what we're all doing if we give you a brief synopsis of what we're going to do initially.
I think, Judge, if there's something that's different than what's been talked about and could be unique to your courtroom, it may be helpful if you give us a few minutes on that. Yes.
Okay.
All right, I guess I'll chime in. I don't think my name's on my phone, Judge Petrucci from Newtown. My district court's a little different being in a borough. We don't necessarily have a parking lot. People kind of scatter and park wherever they can find a parking spot. So the only thing that I ask the affiants, the attorneys, to basically do in my district court is, please just work with the constable at the front door. And, we're doing everything in our best ability to make sure that people do social distance and, follow the rules set forth with, wearing a mask, bringing your own pen, so forth and so on. But I cannot emphasize enough, trying to get everything done virtually, through our Blue Jeans app. I know my district court, I've done several of them already. Lisa Duple's been great at the PDs. We've been doing things, just, pushing paper along. Chris, your department's been great at the DA's level to work with you folks. At the Newtown District Court level, things have been a well-oiled machine. But if we can continue to do this virtually, I think it's just going to keep everybody safer, and it'll keep our court logs moving quickly. So I appreciate all of the support thus far.
Judge Duple, did you want to just maybe run down almost like a roll call list and see if all of the judges have something to say or they don't? It might go a little faster.
Making me find my roll call list.
You don't have all of us memorized? I know you do.
Well, Judge Geyer, you have anything to add?
I do. One, I will not be limiting my preliminary hearings to 10 hearings a day. I am very, very fortunate to have a vast amount of parking in the area, but I will be limiting to one in the courtroom at a time. Additionally, the conference rooms will be restricted. If there are individual needs, not every case needs to have a conference room. And so if there is an issue, we will entertain it, but we have to make sure we sanitize it afterwards. So I'm trying to limit that. They'll be locked at first. If defense attorneys need one, they need to let us know, and then we'll make arrangements to allow that. I will do anything via video, and I also have no problem with the mail. If attorneys have an idea of what they would like to do, they can call me at any time, and we will make arrangements. I'm open to anything to make it work. We have a serious backlog here, so I'm one of those that would be doing this. If I was lucky enough to get reelected, I would still be redoing cases. So it's I'm just putting it out there. Whatever we have to do to get it done, I'm willing to make it work. And that's all I have. Thank you.
Do any of the other judges have anything to add at this time?
The only thing I can add, Mark, and I mean, I'm putting signs out in my front yard saying which clerk is I mean, we'll have a constable as well. This is Judge Armitage, by the way. We'll have a constable at the door, but we will also put some signs out in the yard that will direct, okay, on traffic day, it will be my traffic clerk direct dials. We're not going to make you sit and go through the prompts. So it'll be direct dial right to the clerk in charge for that day. Criminal clerk will have her direct line, civil as well. So I just putting that out there. That might be helpful for people in their cars calling, not to have to sit through the prompts.
Mark, for any of the attorneys that are listening and have cases in my court, I'm going to start with my civil and landlord-tenant stuff and do them like once every 20 minutes, half hour, okay, morning and some afternoons. And then I'm going to do my regular Thursday criminal day with the cases spread out like a half hour apart. And then probably by the middle of July or so, I'm going to get to the summary and non-traffics, and they're going to be scheduled 20 minutes apart. And, you know, we're going to do basically the same thing with the constables and keeping the people outside unless things change by the time, you know, we get to mid-July.
All right. Do any of the other judges have something regarding how you're handling criminal hearings that's different from what we've already discussed? We're going to get through the landlord tenant, the non-traffic traffics, and the civil in a bit, but right now we're just dealing with criminal hearings and those procedures.
Mark, on our criminal hearings, I believe if they're in custody, they're not going to be particularly on our criminal day. Our criminal hearings that we're going to do by video are going to be in the afternoon between 1 and 5. So attorneys might want to, if somebody's in custody, it's going to be between 1 and 5, Monday through Friday. We do not have our particular days assigned to us yet, but I believe that's going to happen in a very near future. And at my particular court in Ben Salem here, we're asking if the attorneys and the defendants, everybody could come a little bit earlier. If they could work something outside before they come in the courtroom. Police officers too, if they could be here rather than walking exactly 9 o'clock. And hopefully no one's going to be late. We can't have people lagging around. So we can keep things moving. I have criminal hearings scheduled every 15 minutes. Hopefully we can work it out. I don't have as many as usual. I did skip a few for a while, but we're going to try to do the best we can and have a soft opening.
And just so everybody knows, if a defendant who's incarcerated is demanding to be present at the courthouse. If they are sent to the courthouse, I understand the constables are only going to be transporting one at a time. But on top of that, if they leave the courthouse, or excuse me, if they leave the prison, there are certain protocols about what's going to happen with the constable and what the constables have to do as far as cleaning their vehicles and everything. But when the defendant gets back to the prison, if they're going to be reincarcerated or continue to be incarcerated, when they come back, they're going to have to go through all the sanitary procedures where they have to get, they swap out their clothes, they have the shower that they have to go through, and then they're also put back on the isolation unit for 14 days before they get to go back to their individual modules where they were housed before they went out for their hearing. Now, if they want to go through that procedure, or they should understand, I should say, that if they're coming to the courthouse for their day as opposed to a virtual hearing, that's the procedure they're going to have to go through on reentry to the prison. So that might cause some to agree to have their hearings heard at the virtually through the courts. Mr. Pollack, I think you guys are working on something with getting us courts set up at the prison, or courtroom set up at the prison. I think he was here.
Yeah, that's correct. What they're planning on doing is, if you folks are familiar with the prison, when you walk in, you have the NPR on your left, and that's where they do the visiting at. They're going to take several of those visiting booths and they're going to turn them into essentially, there's going to be 3 rooms. They're going to put those up pretty quickly using basically 2x4s and sheetrock. They'll have one room for common police court and one room for MDJ court, and then they'll have another room for the inmates. So by having these separate rooms, they're going to be able to do videos on a more frequent basis for both CP and MDJ court. Essentially, they're talking about 8 hours a day for each. The one caveat to that is, of course, right now everybody's housed on the module in their cells. There's no movement. So once the situation gets to a point where they're allowed out of the cells and they can be moved throughout the prison, then they'll be able to be taken to those rooms and used. I don't know how soon that will be. But until that time, and I think Judge Duple touched on it, or Judge Baranowski, they will have tablets and phones that they can take down to the modules, to the cells, to do the hearings that way. So that's the current plan.
Do any of the other district judges have anything specifically on criminal matters?
I have a question with regards to my criminal hearings are generally on Wednesday morning. But now I guess for any of the incarcerated ones, we're going to have to do in the afternoons. Are the district attorney's office and the public defenders on board with that also, to make sure that they have dedicated people there?
I think that's a work in progress.
Hey, this is Chris. As most of you know, some of our people are slightly more dedicated than others. I'll wait for the laughter to die down. No, Judge Duple is exactly right. We are aware that there may be times when we need to staff more. We've been discussing that with members of the Public Defender's Office, and we will be ready. We don't want to be the cause of the slowdown. If we need to figure out some problem solving, what's that called, answers, we will do it. We're lucky we do have interns this summer, so if we need to get through the glut by having some folks who are gaining experience at the same time as they're promoting justice, et cetera, then we'll do that. But we're prepared to go with, I think the most is going to be 4 court staffed at a time, if you think of 3 physical courts and then a virtual court in custody.
All right. Is there anything else, or can we go on to the non-traffic and traffic matters? All right. On non-traffic and traffic hearings, again, we're supposed to try to limit the amount of hearings we schedule at any one time. So we'll probably be doing it more in blocks as opposed to having a mass group of people coming in at one time. At least at my court, I have the luxury, for lack of a better term, that I have a nice sized front porch that's enclosed, or it has a roof on it. So on nice days, so long as there's not inclement weather or some other issues going on, we're going to ask that the participants kind of queue up, and they'll get a chance to talk to their police officer who's involved in the case, the AFIN involved in the case, to try to negotiate whatever you can outside the building. And at that point, you either go into the courtroom or go back to your car to wait further instructions as to when you come in. And then when we come in, the officer will be there, I'll be in there, and you'll work your way through the system, again, just one at a time, until you get to the counter where the defendant will be signing whatever paperwork they need to sign, whether it's a payment agreement or whatever, and then they'll be out the door. Again, we're trying to limit the amount of people in the courthouse at any one time, so we're using the space outside as much as we can, or having people sit in their cars as much as we can, at least at the courts that have that capability. But other than that, I think pretty much the same type of procedure that we're doing for preliminary hearings, trying to do the negotiations outside, we will be doing. Again, there are 18 different district judges. There's 18 ways we do things, as you can tell just by our discussion we're going on here. And also, especially with these cases, the layout of some courts make it that drastically different from others. I don't know that the police departments are going to be, or the officers are going to be willing as the DA's office to take a phone call to negotiate a case before the hearing. I would have to check with my two police departments to see whether or not they would be willing to do that or not. If we can work something out with them, I can certainly let anybody know who calls this court whether or not they can do that. I suspect that's not going to be as easily done as it is in the criminal cases. But when you get to the court, we're going to have all the negotiations done outside. So again, we limit the people inside, get them in and out as safely as we can for everyone involved. Judges, you have anything to add to the non-traffic procedures?
There's
I
two
see no
Mr.
response.
Chairman. I'll add one thing. We're going to ask as much as possible that if somebody's found guilty, that they pay their fines online afterwards to avoid hanging around the lobby and having contact with the staff.
Anyone else? All right, civil cases, again, we're going to try to use the same procedure where we're limiting the amount of cases we call or schedule at any one time. And as Judge Baranowski pointed out, it's already in the rules that if parties and the judge want to agree that we can hear the cases through advanced communication technology, some judges may prefer to do it that way. But if you do, especially if you have exhibits, we need to come to an agreement to pre-mark and pre-distribute the exhibits beforehand, so that when we actually have the hearing, we're not having these delays by not having an exhibit or trying to get an exhibit marked or presented. But if, again, you should check with each individual district judge to see how they want to proceed. But at least if we have a civil case that you can't resolve, and obviously if you resolve it, that's great. But if you can, and we have to have a trial, at least here we're going to ask that all the exhibits are pre-marked and pre-distributed, so that once the hearing goes, we can go forward. Again, as Judge Baranowski pointed out with the Blue Jeans, if there's a hearing and your client might not necessarily be with you, we can put you in the side rooms for discussions to the communication if that's called for. Does anybody have anything on, any of the judges have anything on the civil cases?
Mark, as I said before, I'm open to anything. Maybe a good practice would be to, the plaintiff attorney be on the video, okay, and the defendant, show up maybe, and that's especially true in landlord-tenant cases. I've discussed this already with some of my regular landlord tenant attorneys that represent the plaintiff. And I think we're going to give that a try and see if it works. And that way we'll contain the courtroom into only, having the defendant and their attorney there.
Anything else? All right, landlord-tenant is somewhat complex. And I say that because of the fact that we have 3 Supreme Court orders. We right now have 17 Court of Common Pleas orders. We have the governor's executive order that was just amended this morning, literally an hour or so. And we also had the CARES Act that we have to deal with. So I've created this matrix that all of the district judges have. They can agree or not agree with it, but depending on when a case was commenced is going to depend on what can go on going forward. If the complaint was filed before March 27th, you can proceed after May 31st because the Court of Common Pleas timeline ends on May 31st. So if you have a case filed before March 27th, after May 31st, that can proceed. If you have an order of eviction before March 27th, after May 31st, that action can proceed. If the complaint was filed after March 27th and before May 11th, the case can proceed effective June 1st, unless it's subject to the CARES Act. The CARES Act came in from March 27th, and that continues through July 25th. Again, if the order of eviction occurred after March 27th, and before May 11th, again, that can continue, can occur after May 31st, unless the CARES Act is involved. The CARES Act puts a 120-day moratorium on the commencement of eviction proceedings for non-payment of rent for certain properties. And those properties are if the landlord has a federally backed loan to pay for the property, or if the tenant receives federal rental assistance. If either of those two things are happening, there's federal monies involved, you might not be able to proceed until July 25th, when the CARES Act ends. Now, we also have the governor's executive order that came into play May 11th. And that said, and the governor's executive order was basically that you can't commence an action between May 11th until July 10th. So if the governor, the modification that the governor made this morning, I think it was more of a clarification. All of these issues only deal if it's for monetary reasons that the tenant is in default. If they're destroying property or for like Section 8 housing, if certain events occurred that causes them to not be eligible, these dates don't apply. It's only for monetary breaches of the lease that these dates apply. So if we have an action that is, if they attempted to file after May 11th and before July 10th, the governor's executive order says you cannot do that. If it's filed after July 10th, but before July 25th, the only order that applies is the CARES Act, or the only restriction that applies is the CARES Act. I know this is clear as mud, but that's my best reading of the Common Pleas Court orders, the Supreme Court orders, the executive order from the governor, and the CARES Act. I know that some judges have some questions about how certain things happen. And again, that's going to be up to each judge to interpret how they feel these different acts and orders apply. Because there was an example yesterday where if a landlord has an apartment complex where some of the tenants receive federal funding, can the landlord still proceed against a tenant who doesn't have federal funding, or because of the fact that since he gets some money from that property through federal funding, is there a moratorium on all of them? Some judges think there's a moratorium on all of them because the federal money is involved. Others are of the opinion that it's tenant specific, since the landlord doesn't have any federal monies he's receiving directly from the feds. He's not receiving federal money from a specific tenant, then maybe that can proceed. But again, that's going to be up to each individual judge how they interpret that prohibition with respect to the CARES Act. Do any of the Judge Baranowski, there's also a case currently pending in the Supreme Court.
That was a pretty good summation you did there, Judge Duple. But just so everyone's aware, there is a challenge. There's a group of landlords, landlord groups that filed in the Supreme Court against Tom Wolf and Josh Shapiro, asking for extraordinary relief, asking the Supreme Court to take King's bench power, saying that the governor doesn't have the authority to do this. So that's going to be an interesting case. If anybody wants to follow that, it is 90 MN 2020. That's the case number. So hopefully the Supreme Court will decide to hear that and issue a decision on that. And perhaps that could throw out the whole issue with the executive order as amended.
Judge Duple, we had a few people ask if that matrix that you referenced is something that would be appropriate to share with the attorneys, or is that something more for your own reference?
Well, it's work product that I shared amongst the district judges. As you know what, I'll check with court administration, with our the attorneys up there, and if they feel that it's appropriate for me to distribute it, I'll give it to you, and then
Thank you.
read it. But I don't see that there should be an issue with that. But again, each judge is going to interpret this how they do. You know, I have my ideas about it. I mean, the rules and the orders don't change, but just the interpretation might change between the 18 of us. And as I've said earlier, there's 18 different ways we do our job in Bucks County. Do any of the district judges have anything to add on landlord tenant? Do any of the district judges have anything they want to address generally that we haven't covered, or want to clarify things? If not, I'm going to ask Dan if he has any additional questions for us.
We had a question about, again, I think going back to that issue of mail-in waivers of preliminary hearings. Is that something that generally the courts are accepting?
Yes.
I think that's a personal thing, or an individual thing. I know that depending on the circumstances, I accept waivers by mail on occasion.
Okay.
Now,
I'm accepting them. I haven't heard of any judge that is not accepting them by mail at this point.
I think most of us are accepting them by mail. The object is to get the least amount of people to the court as possible so we can reduce the possible spread in attendance.
If they're unsure, contact the court and ask, just and make sure. That's the best suggestion.
Sounds like most of the judges are accepting. Are there any judges who are not, just so people know to call there and be aware of that? Okay, I haven't seen anybody, so all right, I think that should clear it up.
Hey, we agree on one thing.
There's always that one thing.
Dan, you had anything else?
There was a few questions about I think you touched on this, but it keeps coming up on the side about traffic tickets, citations, even non-traffic. Are those, if they're going to be resolved or some kind of resolution, is that something that can be done by mail or by video, or do they have to be in person?
I think I like email the best. That way I have some record I can put in the file with the case, and we'll take any plea arrangement deal by email for traffic or any summary matter, non-traffic as well.
Are there certain types of citations, like ones that would require incarceration, that people would have to be physically present for?
I think if it's a 1543A 6 offense or more, or a 1543B, we're probably going to have to see them, because we have to give them their instructions about how they have 37 days from the date of the conviction before they have to report, so that they have the ability to be screened for house arrest or some other type of service like that. So that one might, although if the attorney's there with them and we do it, when I say in person, I think if we could do it by video, but I don't know that that can necessarily be one that you do just through email. It's just my off the cuff thought.
Yeah, I personally agree with Judge Duple. I mean, I think if it is something like, a 6th offense, habitual offender, or incarceration, it should be not done by email, but it could be done with ACT, in my opinion. I just think that the defendant needs to get proper instruction, with or without the attorney at the initial hearing.
We've been talking about advanced communication technology quite a bit this morning, and it's our understanding that the Supreme Court is going to issue an order that although the court emergency is still going to end on May 31st, they are going to order that we can continue with advanced communication technology to the extent possible throughout the whole COVID crisis. So the more we can do things virtually, I think it's the safest way for everybody involved, the judges, the attorneys, the participants, our staff. So we really encourage everyone, to the extent possible, and again, this is a court by court decision, but to the extent possible, if we can do something by video, let's do it that way.
And I think, Judge Duple, you touched on this, that we do expect a Supreme Court order to come out any day now, that will then be followed by another emergency order from Judge Bateman that will address how things will apply to Bucks County. So we're waiting for that. As soon as we have that, we will distribute it to the members. So just a couple of other quick things that we received. If attorneys are able to work out some type of plea agreement with the DA's office or the police officer directly, they can be the one to initiate that contact with the court and just copy the attorney or the DA's office or the police. Would that be generally correct? They don't have to wait for the police or DA's to be the one to initiate that communication?
Can I?
If it happens that way, I will end up calling the DA or the officer just to confirm, and then I will send them a confirming email that they're in concurrence. I really think that we have to have something in writing that the DA or the affiant agreed to the amendment that we'll put in our file.
Judge Armitage, did you want to add something also?
So I'm just so I'm clear. Are you saying that the attorneys will reach out to the officers?
If an attorney speaks to the DA ahead of time or speaks to the police officer ahead of time and they reach some type of resolution, I think attorneys are probably looking at it like they just want to get the ball rolling and move that process along. And they're wondering, can they be the one to first contact the court, understanding that the court may then contact the DA's office or the police officer to confirm, but they just want to know that they can kind of control getting that process started.
I think if the attorney emails the court and CCs the officer, that would probably satisfy everybody's concerns.
That would work. That would work.
Okay.
Hey, Dan, Judge Peranto here. I'd just like to say, everything that we've discussed here is not off the table as far as I'm concerned in my court. I'm going to do whatever it takes to try to make it convenient for everybody to get through this process, and it's going to be a long process before we get back to normal. But if an attorney has a question about doing something, have them contact me. I'll discuss with them, or I'll set the guidelines, and hopefully we can move the cases forward so that we can get caught up and get things out of the way.
And then the other thing that came up here was if we have a criminal case that then resolves in a summary offense instead, does that require an in-person visit, or can that possibly be done by ACT?
The Supreme Court is encouraging us, and Judge Bateman is encouraging us to do anything we can through advanced communication technology. If we're having a hearing, I don't care if the defendant's sitting in the courtroom or sitting in a virtual courtroom, as long as I can have that discussion with them and colloquy them to the point that I feel is appropriate. Virtual technology is acceptable. And again, that's going to be a judge by judge basis, but I think the majority of us are of that opinion.
And it sounds like what most of the judges are saying is that with everything we've talked about here today, don't be afraid to ask, or at least send an email or send a letter or call and say, what's possible in this unique set of circumstances? Can we do this or can we do that? And that the judges will be open to at least hearing out those requests and then figuring out what actually works.
And I would actually take that a step further. We've been meeting weekly to try to figure out the best practices going forward. But if somebody hears something that they think there's a better way to do it, I'm not offended if you contact me and say, hey, I understand you want to do it this way, but did you think about this, or can we try that? And I think all the judges, we're just trying to figure out the best way to get everything going again and back to moving our cases along and getting this thing going.
Right,
I concur with
what I've seen.
I concur with Judge Duple. I mean, it's a learning curve for everybody, so if anyone does have any ideas, to make it, smoother, please, don't hesitate to let us know.
If any of the attorneys have summaries or non-traffics in my court, I would even maybe encourage you to maybe bring them to your office, dial in virtually. Okay, we can hear the case, and whatever the plea is or the resolution, we can always scan and email you a plea. God, I'm losing my mind here. Something for them. Yeah, I can't. Something for them to make a plea on. The printed out form that we have when we don't do it on the back of the hearing notice. Basically, the one we use for the e-filings.
Okay.
Yeah. So the disposition sheet. So and then we can mark that whatever the outcome of the hearing is, and that'll be the end of it, and it'll be, all done virtually. Or if you want to stay in your office and send the client to the court, I'm okay with that too.
And any video that's done in the courtrooms or by any of these will always be done by Blue Jeans, right?
I'm not answering for the other judges. We have Blue Jeans here. But I can tell you if somebody has a Zoom or something else and that's all they have access to, This is Armitage. I'll work with other options, but I'm not, Blue Jeans is the preference, but I don't know what other judges, if they have other options available.
If you don't have,
if somebody uses Zoom or something, if you're not the administrator in that account, you're not going to have certain options for the private breakout rooms or different things that you might need.
Exactly.
Or the ability to mute other people that might join in, because these things still have to be open to the public by the rules. The reason we're using Blue Jeans is we all have our own accounts by court administration on that, so we can administer those rooms and control those different variables as far as the private breakout rooms or muting other people, that somebody that might pop in there or keep things waiting. One other thing I would mention, though, for all the attorneys, if we're scheduling these proceedings by ACT, what's going to be important is time. So if you have a preliminary hearing scheduled at 2 o'clock, we're going to have to be ready at 2 o'clock because there's going to be another one coming up, maybe 20 or 30 minutes later. So timing is going to be important. So we would ask for everyone's cooperation so we can uphold those times that they are scheduled.
Yeah, I'd like to add that as far as the ACT is concerned with summaries, civil cases, I would certainly like advance notice. I'm not opposed to using ACT, but if you have a client that you're representing for a summary case or a civil case, criminal, I'm sure we'll discuss prior to that. But on those cases, I would rather not get a call at 8:30 in the morning and say, hey, my client's here, we'd like to do it by video. I'd like to at least have some advance notice, a day or so I know who's going to be here and know who wants to do it by video.
I had a question, Chris Reese, if he. Chris, are you here?
I'm still here. I missed the question.
Yeah. When I know we're going to be having interns again handling these hearings, are you going to have a plan in place where they can actually reach somebody to try to make waiver agreements so that we're not, because these cases will pile up on top of each other if we don't have the process flowing properly. So just hope that they'll be able to do that.
There should be at least 2 senior DAs available for any intern questions at any time.
Okay, good.
And Chris or Bob Pollock, anything else that you thought you wanted to add?
No.
Okay.
Just,
all right.
I would ask everybody, this is a very fluid situation, something we've never encountered before. And, I've been impressed by the way everybody has tried to work together to resolve the issues. And I would just ask that we continue to do that going forward. And just like, I think it was Judge Baronas or Judge Duple, if you can think of things that we can do better, by all means, please reach out to me or to the judges, and we will certainly, take it into account, see what we can do.
All right, thank you, Bob. We appreciate it. Anything else from the judges?
I just want to thank everybody for participating today. Hopefully the information we gave you will be helpful, and we'll get through this as best we can.
All right, thank you for all the judges participating. We really appreciate it. And we have a Court of Common Pleas conference next Thursday at noon that will shed some more light on these same issues at the Court of Common Pleas. So thank you everyone for participating. There will be a copy of this on the Bar Association website so that you can watch it again later, or if you need to forward it to anybody else who wasn't able to be here today. So we appreciate everyone's participation, and have a good day.
Good holiday.